One of the SEC's main role is to develop the Thai capital market and to support the creation of financial and investment innovation, such as derivatives, trusts, and digital assets, and to serve as a center for investment knowledge for the general public. By placing an emphasis on investor protection, the SEC not only accepts complaints relating to the capital market, but also gives information and advice to the public. We are SEC Help Center at 1207, 24 hours a day, every day. At the same time, the SEC has been in close cooperation with international regulators and organizations to keep driving the Thai capital market towards sustainability on par with international standards. Thailand will be on the road to sustainable growth when its economy strengthens and the capital market becomes solid. The capital market serves as a catalyst for economic growth by providing access to capital for investment projects, both in the public and the private sectors. The capital market is, therefore, fundamental to the country's economic success and plays a key role in the life of all citizens to ensure that the supervision and development of capital market is effective, reliable, and accessible to every sector. The Securities and Exchange Commission, or the SEC, was established on 16 May 1992 by virtue of the Securities and Exchange Act 2535BE, or 1992. The SEC has a key role in supervising all of those concerned in their relationship with the capital market. For businesses that raise capital by offering securities for sale to the public, the SEC will ensure a complete information disclosure to bring confidence for the investors' decision-making. The SEC grants licenses and supervise professionals who have the duty to assist and prepare the business of issuing securities for sale. In overseeing the stock exchange, the SEC ensures that the system for trading, payments, and delivery of securities are effective, and the securities or payments are delivered properly to the investors. The SEC also supervises the stock exchange and monitors irregularities in trading, which would lead to investors being taken advantage of, and to refer any suspicious matter to the SEC for investigation and discipline where it is appropriate. In granting securities business license, the SEC oversees the licensing process and the performance of personnel, such as investment advisors or fund managers, and ensures that they provide proper service and advice and protects the investors' assets. Furthermore, one of the SEC's main role is to develop the Thai capital market and to support the creation of financial and investment innovation, such as derivatives, trusts, and digital assets, and to serve as a center for investment knowledge for the general public. By placing an emphasis on investor protection, the SEC not only accepts complaints relating to the capital market, but also gives information and advice to the public. We are SEC Help Center at 1207, 24 hours a day, every day. At the same time, the SEC has been in close cooperation with international regulators and organizations to keep driving the Thai capital market towards sustainability on par with international standards.
Good morning, good afternoon, and good evening, international guests and international participants who is now joining us here in the webinar. organized by the Securities and Exchange Commission of Thailand. And my name is Vitsit Tivekin, and I would like to welcome all of you officially to this first ever SEC Thailand International Digital Asset Webinar under the theme Policy Implication for Digital Asset Regulation, a peek at global movements. And of course, today our highlight is the exclusive interview together with the Commissioner Hester Peirce, who is the Commissioner of the US SEC, who will be sharing together with us her views as well as practice, what she has learned in the US, as well as to share this together with us. And the interview, which will be taking place within the next minutes, will be approximately 40 minutes, and the last 5 minutes will be kept for the questions. And therefore, I would like to urge all of you, should you have some questions, you can write it down and drop it into the chat box, and our editorial team will collecting all of that, and hopefully, if the time allows, that will be get answered by Commissioner Peirce this evening. I mean here the time here in Thailand. But before anything else, I would like to proceed further to the formality for this evening, and I would like to bring all of you to the welcome remarks and introductory remarks by the Secretary General of the SEC here in Thailand, Commissioner Runwadi Suwannmongkol.
Commissioner Hester Peirce, distinguished speaker, distinguished guests, ladies and gentlemen, good evening and สวัสดีค่ะ It is my honor and privilege to welcome all of you to the first SEC Thailand International Digital Asset Webinar. We truly believe that this webinar is organized at the right moment, which will be resourceful to all. In just over a few years, the global financial market has changed dramatically owing to the emergence of distributed ledger technology like blockchain and digital assets. The technology has introduced a new and perhaps more efficient way to conduct conventional transactions, ranging from fundraising activity to trading in asset and financial instruments. Thai capital market is a part of this global development. Regarding digital assets, may I keep you all updated briefly. Thailand is one of the first countries to come up with a regulatory regime for digital asset and related activity. In May 2018, the emergency decree on digital asset businesses has been introduced, following the rise of ICO in late 2017. Indeed, the law provided legal clarity on the digital asset business while ensuring an investor protection mechanism. Blockchain and DLT technology are widely adopted in various sectors, ranging from financial and payment sector to real sectors such as energy, entertainment, sport, and art. It is witnessed that goods and services offered in real-world markets are now tokenized and traded in blockchain-based platforms across territory and regulatory borders. Among other challenges recently, decentralized finance or DeFi might be a major challenge for regulators worldwide. In DeFi space, there is no intermediary, and therefore it might be difficult to find the contact point between the space and regulatory sphere. Consequently, this may force a regulator to rethink about regulatory framework that should be properly applied to the digital asset market. I hope this webinar will bring together hundreds of professionals and experts from both public and private sectors, which will be a forum to discuss on solutions to those questions and thus together find the proper balance between protecting investors and supporting businesses and innovation. Additionally, to ensure regulations will work for every stakeholder, it is crucial, as I generally believe, engagement is one of the key factors. That is, to engage with industry, not only local but also global players from other jurisdictions. Ladies and gentlemen, before I end, I would like to take this opportunity to express my profound appreciation to Commissioner Peirce for giving us time to join the live interview tonight. I am deeply grateful to Commissioner Peirce for her kind support. Personally, I admire Commissioner Peirce for her distinctive works on digital asset, as well as her openness on this cutting-edge technology. Today, I must say that it is such a great honor for me and SEC Thailand to have an opportunity to discuss with Commissioner Peirce. My special thanks also go to Professor Douglas Arner from the University of Hong Kong, who will provide his economic outlook on the digital asset regulatory policy, and to all guest panelists from the Blockchain Association Singapore, Crypto UK, Baker McKenzie Zurich, and Upbit South Korea for joining our industry panel discussion tomorrow afternoon. In addition, we are very fortunate to have the generous support from the UK government ASEAN Economic Reform Programme, Baker McKenzie Thailand, and the Thai Digital Asset Operator Trade Association on supporting this event. Last but not least, I would like to convey my sincere appreciation to all distinguished participants for taking this valuable time to join this webinar. My thanks go to Dr. Vit Sithivekin, who will be a moderator for these 2 days. I sincerely hope you will enjoy and gain benefit from both today and tomorrow's sessions. Thank you.
Well, and that is the introductory remarks by the Secretary General of the SEC here in Thailand, Commissioner Runwadi Suwarnmongkol. And I think that majority of us might agree that the 21st century, especially in the first 2 decades, seems to be the era of emergence of new technologies and innovations. And the point here is how to deal with them appropriately. Well, and in the next 45 minutes will be the highlight for this evening sessions, which will be the exclusive interview with the US SEC Commissioner Hester Peirce. Before I proceed further, I would like to remind all of you that some minutes at the end will be kept for questions from the floor, and hopefully that will be answered by our guest speaker for this evening. Therefore, I urge all of you to drop your questions into the chat box, and the editorial team will proceed further to the conversation as well. And now I think Commissioner Peirce is here together with us online. And I would like to welcome our guest speaker for this evening, Commissioner Hester Peirce.
Well, it's a delight to be here. Thank you so much for having me. Thank you to the Secretary General for her wonderful remarks, and to the SEC Thailand for having me. It's such an honor to be with you all, and thank you to all the participants. I do have to start with a disclaimer. My views do not necessarily represent the views of the United States Securities and Exchange Commission or my fellow commissioners. And with that, I'm looking forward to getting into a great discussion.
Thank you very much, Commissioner Peirce. It is our great honor and pleasure to have you together with us here. First of all, I think that majority of those who are together with us in the webinar here, they are regulators, and they might ask, well, what is the role of the SEC in the US in regard to the crypto asset market? And I'm sure that in the US, it is not only the SEC who is the single regulator in this particular regard. How do you, SEC in the US, work together? How do you divide the tasks among each other? I mean, regulating bodies in the US.
Well, it's a difficult issue in the United States. We have so many regulators in the financial sphere in the United States. We have regulators both at the federal level and at the state level. And so figuring out who has jurisdiction over what in anything is difficult, but I think in digital assets, it can be even more difficult. So we are certainly working together. There is work through something called the President's Working Group, which brings together financial regulators. The Financial Stability Oversight Council brings together financial regulators, and then informal work among the different federal financial regulators. And then there are efforts in our Congress to figure out who should have jurisdiction over what. And so it's really a work in progress for us, and it certainly is not a fast work. One of the concerns I've had is that a lot of the action so far has been through enforcement, And so what ends up happening is different regulators sort of claim their jurisdiction through the use of enforcement. And I think it's better to try to set out some clear parameters ahead of time and say, this is how we're going to allocate jurisdiction among the regulators. But it's very much a work in progress.
Well, thank you very much. Well, another thing that I wish to ask you, I think that last year, as far as the Ripple Inc. is concerned in relation to the XRP, at that time, the US SEC's team seems to rule that as the investment contract. I would like to ask you to elaborate further about what are the rationales and what are the reasons behind those rationales to rule in that particular way.
Well, so let me not talk about any specific enforcement action by the SEC that's ongoing, but instead, let me just tell you a little bit about how we have approached digital assets at the SEC. We've typically looked with some concern at sales of digital assets that have been connected with raising funds, and we've looked at that through the lens of the investment contract. In the United States, we have a very broad definition of security, and one of the pieces of that definition is an investment contract, which is intended to capture anything where someone goes out and says, I'm raising money, you give me your money, you don't have to do any work, and I will produce a return for you based on your investment. And so through that lens, we've looked at digital asset sales as securities offerings. I think that there is a bit of a problem with that because sometimes it's unclear whether we're treating the digital asset itself or the offering of those digital assets as the security. In any event, we have to think further down the line. If we designate something to be a security, then necessarily all of the securities laws apply. And so how does that work in the digital asset context? We haven't really gotten into that. We haven't developed a framework about how those securities laws could apply in the digital asset context. And so I think that is a really problematic situation in the United States, and something that I've had some suggestions around how we might create a safe harbor so that people could do token distribution events, provide information to purchasers of tokens, information that's relevant in the digital asset context. And then after a period of time, once the network is developed, they could move out of the securities framework entirely.
Well, thank you very much. The token safe harbor will be our next questions then. But now, I think that the crypto asset market has been up and running already, and some of the jurisdiction has already been developed a set of regulations in order to regulate those markets already. And do you think this is the right timing for governments or regulators in order to develop a set of regulations in order to deal with the development of those crypto markets?
Well, I really like that question because I think there are a couple things going on. One, on the one side, you may want to wait a little while to develop a regulatory framework so that the industry can grow and you can kind of see where the issues might be. On the other hand, not developing a regulatory framework in a timely fashion could mean that people meaning innovators, are spending a lot of time thinking about, might I face an enforcement action down the road? What are the rules? How can I do this legally? Instead of thinking about how can I innovate, thinking about the technology. And so I do think now is a good time to develop some basic parameters within which the industry can develop. And I really liked what the Secretary General said. It's this idea of balancing investor or customer protection on the one hand, and on the other hand, ensuring that innovation can happen in this new space. And getting that balance right is important. And I think, frankly, we have a lot to learn from other jurisdictions as well. Everyone is trying to figure this out. So we all can learn from one another, which is something the Secretary General and I also spoke about, it really is important to try to learn this together and figure out the right regulatory approach.
Well, thank you very much, Commissioner Peirce. But one point you mentioned about the word balance. On the one hand, innovation moves on. And I think that governments and regulators need to promote those innovations. But on the other hand, you have the investors to be concerned. What is the optimal balance from your point of view, or what is the approach that we can reach what is called the optimal balance between the two?
Well, I think in this area, as many others, it's a difficult question to get to that right balance. But I think that we can achieve this by setting out some clear rules and setting expectations for people innovating in this space, and also expectations for consumers, investors participating in this space, in the sense that we have to be very clear about what our regulatory guidelines are, and so that people know if they're going to buy tokens, who's going to be protecting them, if anyone. If our platforms, let's explain whether platforms are regulated or not regulated. And this is a point that my colleague at our sister regulatory agency, the Commodity Futures Trading Commission, Dawn Stump, she's made this point. She's put out some statements to say we need to be clear with people about where exactly our authority is and what it extends to. I think that piece of it is very important. Set expectations for both innovators and for investors.
May I ask, when you mentioned the term clear, clarity is something quite difficult. Which particular point that we should address, which should be clarified, which particular points has to be clear, Commissioner?
Well, that is a good question. So I think the first thing that needs to be clear, and again, I'm speaking from the United States perspective, where we have this very broad definition of security. So point one, let's be clear about what is a security and when we will treat something as being offered as a security. Second, I would say we need to be clear about how different entities that we regulate can interact with digital assets. Again, we have a lot of rules around that. We've started to provide some safe harbor guidance around that. But I think that piece is very important. How, for example, can a regulated entity provide custody for a digital asset? What does that look like? And then I think another area where we in the United States are working is around exchange traded products that are built on top of digital assets. The SEC just allowed to go forward an exchange traded product, an exchange traded fund based on Bitcoin futures. That was within the last couple weeks, and that's our first real foray into exchange traded products based on that are widely available based on crypto. So that's another area we should be providing clarity.
Thank you very much. Your answer upon the clarity is very clear. So one thing, when people think about regulations, many people would have some perception that regulations mean, obstacles to further development of the innovation. If we need to think about developing regulations, what kind of feature of those regulations should be in order to maintain that optimal balance that we have discussed early on?
Yeah, and I think that's an interesting way of phrasing the question, right? We on the one hand, regulations can be perceived as an obstacle, but if you're able to get the regulations right, then they can actually be a facilitator of innovation, because again, people are comfortable, they know where the boundaries are, and they can operate within those. That leads to the real answer to your question, which is I think rules need to be they can adapt as the industry changes. We've seen in the digital asset space that things change extremely quickly. And so trying to write a set of rules that will adapt with the change is quite is quite hard. We talk about principles-based versus prescriptive. I think it's best to have as principles-based an approach as you can, to not write any particular technology into your rules. And I will say this is not an easy task. I think if you look at the safe harbor that I proposed, one could argue that that's too technology specific. And so again, I'm open to feedback on how one could construct a safe harbor that would be as technology neutral as possible. I think that's a real key to allowing people the flexibility. Otherwise, what happens is you end up putting into the rules the regulator's vision of what the future will be. And regulators, because our job is regulating, not innovating in the technology space, we can't see what is going to be happening in 5 years, 10 years, 20 years. So we have to be very careful not to put our vision of the future into the rules, but to allow that to be more open-ended and welcoming to innovation that we wouldn't even have thought of.
Well, I like that. Technology neutral. Thank you very much for that. But now, a lot of people, are very interested in this concept, which is token safe harbor. But we wish to know what are the key elements in there. Once we think about, well, we should design a kind of, I don't know whether it's an equivalent to sandbox, but I think, from my own perception, it's like a sandbox. What should be the key elements that regulators should think about before they design that kind of token safe harbor?
Others have described it as a sandbox as well, and I think that description does work. What I was looking at is when I saw all of these attempts by people to distribute tokens to a wide set of people so that people would be able to use the network on which the token is the necessary coin. What I saw is that people didn't know how to do that in a way that was compliant with the law. So the safe harbor is designed to say to people, you can come in and tell us that you're going to do a token distribution event, then put out disclosures saying who is the team working on this, what are your plans, what are the economics of this token distribution, and then you'll give this set of information. You put the code out there. The code needs to be open source, and then as time goes by, through a 3-year period is what I have in my safe harbor, you would update those disclosures, provide people progress reports on how things are going. And then at the end of that time, the goal would be that the network is decentralized, that the token is serving as a utility token. And at that point, you could pull yourself outside of the securities law framework entirely, because that wouldn't be the right framework anymore. So the goal is to say, we know we want to address the information asymmetries. The team developing this network has a lot more information than anyone else at the beginning. By the end of that process, everyone should be on an even playing field. Everyone has the same information. And at that point, it doesn't make sense to have the securities laws apply at all anymore.
Thank you very much. And another question is, this is, if I understand correctly, you once mentioned about the integration of the digital asset markets and traditional investment markets. That's the utilization of the new technology in the new world into conventional investment houses. Can you elaborate a little bit more on that? What is the benefit of that? And of course, what are there any kind of risks in that? And what should regulator position themselves as an enabler of that process?
Well, there certainly are risks. I think anytime you bring in something new, you have to be concerned that how are the new things going to interact with the traditional securities? So those are questions that we certainly are trying to ask. And I think people need to be thinking about what are the risks that could flow out of digital assets that are unique to digital assets? Is there anything that we need to be thinking of ahead of time in that regard? But I do think the technology underlying digital assets will end up being integrated into other parts of the securities markets over time. And I suspect that they'll be integrated in a way that the end user, the investor, is not going to really even know that the technology is behind what they're doing. But in the meantime, I think a lot of people are trying to get exposure to digital assets, and they want to do that through the same way they get access to other types of assets. And so it's important for us to allow regulated entities to offer these kinds of exposure to these kinds of assets to their investors in ways that those investors are comfortable. So we really need to work through the details of those kinds of questions. And I think that's something that we can only do in conjunction with people who have experience both in the traditional markets and in the digital asset markets. And that's why I think it's encouraging to see institutional participation in these markets. Those institutional entities bring an understanding of what some of the challenges might be. And I think together we can work on addressing those challenges.
Well, thank you. Another feature of the digital asset market is it seems to be a very information sensitive. In a way, it's very news sensitive. And the point is that sometimes regulators might ask, well, what should be our role in communicating, or how should we position ourselves? What should be the ideal role that I should do? Should it is over sensitive in terms of the news and information? Any kind of suggestion from your side?
Well, I think that's another great question. It is incumbent upon regulators to be careful about how they communicate around digital assets, because people are watching and listening and sometimes drawing wrong conclusions about what's going on based upon a remark from a regulator or a decision by a regulatory agency. So I would say, one, it's important to be clear, and I alluded to this, or I talked about this earlier, which is be clear about where your jurisdiction lies, so that if someone comes to the SEC now and says to me, I had a problem with a platform, a trading venue for digital assets, can you help me? I think the SEC needs to be clear that we do not have authority over trading venues that don't trade securities. So unless the digital assets are securities, we don't have authority. So be clear with people. I think be clear with just what the rules are, and assume that people who are engaged in this space do not know how the traditional securities markets are regulated either. I think we often jump to conclusions that people have this deep knowledge of how the SEC works, for example. And then we assume that they're going to be able to figure out how the SEC works in connection with digital assets. And I think there's not enough clarity around either point. So provide that basic backdrop about what it is that the SEC does, and then from there explain how that will apply in the digital asset context.
Well, Commissioner Peirce, one thing in the digital world, I think that the news is traveling at the speed of light. At the same time, I mean, regulators need to be cautious about everything that you communicate, but sometimes it might be a time-consuming process. What should be the optimal balance? I mean, optimal balance come into play again. What should be the best way that we can handle that in an appropriate way possible, from your point of view?
Well, I think it's a difficult balance, because you're right, regulators are cautious, and regulators are often unwilling to provide something very specific because they're always facts and circumstances. A lot of us are lawyers by training, and we know that you can say one thing, but if one fact changes slightly, then that one thing might not be true anymore. So I'm going to point to something that our agency recently did outside of the digital asset space. We have a very complicated set of rules around raising capital in the private markets. Particularly, there are a lot of different ways you can do that in the United States. And so often someone who's starting a new business wants to raise money but doesn't know how to do it. And so coming to the regulator to try to get help with that is often frustrating because there's so many rules. So our staff recently put out an interactive tool that you can use and that you can answer questions, and it will suggest to you, these are some options that you might consider given the facts and circumstances of your capital raise. And I think that kind of interactive tool is a good way. It's a good experiment for us. Are there more instances that we can use those kinds of tools to guide people through what is a very difficult set of rules?
And I don't know whether this is under the authority of SEC in terms of promoting the literacy of people in terms of digital asset markets. How would you advise? Because this is new, and I think that some of those who invest money in this market, they might not be aware of what kind of risk, because some of them, they might not be well informed and so on. What should be the ideal role for the regulator in order to plan about enriching crypto asset literacy?
Well, in the United States, we do try to offer investor education resources around a number of issues, including digital assets. One concern that I have is that often our approach to educating is a very traditional approach, meaning that we put out on our website a risk alert, something to tell people. It describes to people what the potential risks might be, and it's not the kind of thing that I think a lot of people will sit down and read. So I think some approaches that we've taken in the past maybe are a little more creative, and we need to continue to think creatively. For example, our staff in our Office of Investor Education created a website offering a fake digital asset, the Howie coin. And it looked like, there was a white paper. It looked like it was a real offering site. And when people clicked on it, a warning came up and said, be careful. You need to do your homework. You need to avoid getting scammed. You need to avoid getting defrauded. And I think that kind of approach is creative, and it's more likely to reach the people who actually might not take the time to read one of those risk alerts that we put out. So creativity, reaching people where they are, is very important.
I like that. Creativity, reach the people where they are. Well, we have read some of the report, and it is reported that the US government and the Congress are considering tightening the rules on digital assets. Will the US move towards a stricter approaches, and will we shortly see the digital asset laws in the US from your point of view?
It remains to be seen. I think, again, there are many financial regulators who have potential input on what those rules will look like. And there has been increasing interest in Congress to define clearer rules, to set jurisdictional rules around digital assets. Congress has a lot of things to work on, and so whether it will have the time and attention to devote to digital assets, I don't know. But I do think that we'll see in the coming year, we'll see more activity by regulators to try to think about how to define jurisdictional boundaries and define rules in this area.
And now I would like to go up to another questions about the decentralized finance. What is your view upon that decentralized finance? How would you think it will happen, and what kind of new opportunity, what kind of risk do you foresee?
Well, I think the Secretary General was correct when she said that DeFi poses a challenge to regulators. This notion of removing centralized intermediaries and having peer-to-peer transactions, people interacting with one another through the mediation a smart contract, it's something that's unusual for us. We're used to dealing with centralized entities, and often these are centralized entities that we know very well, that we're used to interacting with. So it's easy for us to be picking up the phone and calling someone there and telling them, that we have concerns about something. In the DeFi space, when it's truly decentralized, there is no one you can pick up the phone and call. And that means there's no one that an investor or consumer can pick up the phone and call. And so that is a very different model. And I think we are right to be looking at that, and particularly given how quickly it's growing. But there are some positive sides too. And I think as we look at DeFi, we need to bear those in mind. One, DeFi does allow for broader access to the financial system. I think every country has the problem of certain parts of society have not had as equal access to the financial system. This is a very democratizing technology. It allows anyone to interact on the same terms in a very transparent manner with a particular financial contract, right? And so that's a positive thing. And another thing is, I think there's resilience to the fact that if you decentralize something, you don't have the particular points of failure in large centralized intermediaries. And so let us, as we think about regulating DeFi, let's look at those positives. Let's think about how can the DeFi itself perhaps displace some of our role as a regulator, because the code itself acts as somewhat of a regulator. So let's take advantage of that. Let's not assume that's a negative, but let's take advantage of that. We have a lot of work to do on thinking about DeFi, but I would caution us to do it with an open mind to the benefits and maybe some of the regulatory work that can be done by code instead of by us as human regulators.
Well, Commissioner Peirce, when regulators think about what should be the ideal approach in order to approach the DeFi, what are the key points that you wish to pinpoint and share with us here as the regulators at least can use as the framework when they think about DeFi, should it come to their jurisdiction?
Well, and I'm sure it already is in their jurisdictions because it certainly has grown so fast in recent years. So first I would say, remember that technology neutral point. Be careful not to write rules that will be outpaced by the change in the technology. Two, I would say talk to people in the DeFi space. And when you invite them to come talk to you, invite them in with an open mind. People do want to share what they're doing, but they have to do it. They have to know that the regulator wants to learn and hear. And three, I would say, this sort of harkens back to what I just said, which is take advantage of the technology as an aider of regulation. This technology, because it is based on smart contracts that are open source, or if it's truly decentralized, right, it should be based on open source code so that you can see what's going on. And that code can serve as a regulator to make sure that everyone is treated the same way, and you can get a sense of what's happening. I would also say that you should be careful not to attribute back bad things that people do with the code back to the person who developed the code. We want there to be a lot of freedom around people developing code. So those are some things I would say regulators should think about. I think people who are engaged in the DeFi space need to be thinking about whether their DeFi applications, whether they truly are decentralized. Are there central points of failure built into the code? Does someone have control over a large treasury, for example? How is that being managed? Is that being managed by the community at large, or are there a few people who have special rights? Those kinds of questions are things that people developing in the DeFi space need to be thinking about.
Thank you very much. These are all the questions that I wish to ask you. And now the questions from the floors are flooding in. And therefore, I would like to ask this opportunity to address these questions to Commissioner Peirce. First, one of the participants said, I was confused by the US SEC definition of coin-based lending program as a security. When will a framework be put in place to provide clarity on what types of crypto assets will be classed as securities?
Well, again, I want to be careful not to talk about any particular company or product. But what I will say is I talked about the breadth of the definition of security in the United States. And I talked about one specific aspect, the investment contract aspect, which is something that's been talked a lot about in the crypto community, particularly the Howey test, which is the Supreme Court case that sort of defined what an investment contract is. There are other aspects of the definition of security which can capture a broad range of debt-like instruments. And so people do, as they're developing products in the United States or offering products in the United States, need to think about not only what an investment contract might be, but what some of the other what the other aspects of the definition of security might be and how that might touch what they're doing. And again, it is quite a broad definition in the United States.
Thank you. And another question is from Purin, I think the name is Thai. Would there be any enforcement, punishment, protection against cryptocurrency price manipulation? For example, the connection between Elon Musk and Dogecoin. I mean, this is by the one of the participants.
Well, again, I don't want to talk about any particular crypto asset or person, but the question sort of goes back to the prior question, which is what is a security? And if something is a security, then we have authority around that, and we may, we do with traditional securities sometimes bring cases about manipulation, for example. If, however, the asset is not a security, that wouldn't be within our jurisdiction. And that might be something, if there is a futures market, for example, so there are futures markets in the United States tied with Bitcoin. They're Bitcoin futures markets. So theoretically then, the CFTC, which is the regulator of the futures markets, might have something to say about manipulation in the underlying markets. But I certainly don't speak for the CFTC, so I'll leave that there, but say it does depend on whether the crypto asset is a security or not.
Thank you. Another question by Pitch Rithi. Can regulators use sandbox technology to regulate the digital asset?
Well, I think developing a sandbox is a useful way for regulators to get some insights into what is happening, to be sort of getting a nice view into the development of this technology. So if you set up the sandbox in the right way, I think it can be a really important contributor to the knowledge of the regulator. But one concern that I have about sandboxes is that it can be very difficult for people to develop and try and experiment under the eye of the regulator, with the regulator basically sitting alongside, because the experimentation process is a very dynamic process. And so sometimes the way a sandbox is designed, you have to check at every point and get approval from the regulator if you deviate slightly from what you plan to do in the first place. And that can be a bit confining. So I think the key to developing a good sandbox is allowing enough flexibility so that the technologists, the entrepreneurs don't feel constrained and are able to really experiment, fix things that aren't working, address problems as they arise.
Thank you, Commissioner. And I think there might be time for another two questions. What would be your recommendation as a roadmap to develop the regulatory framework for the digital asset for the countries that are technologically behind?
Well, I think this is a time when countries have a real ability to design a smart regulatory framework, and it can be more difficult for a country like the United States that has a very developed set of securities rules and a very developed set of case law around those securities rules. So if you're writing from a blank slate, if you're writing on a paper that is less filled with rules than ours is, then I would say bear in mind that technology neutral suggestion that I made before. Having rules in place that aren't based on the technology of today, but are much more open-ended, I think will be useful. And then take advantage of the technology. Technology offers us as regulators new tools that we didn't have before. So take advantage of that. But as a cautionary note to that, I would say be careful to preserve the ability of people to engage in transactions with one another without surveilling every one of those transactions. That's something that technology may enable us to do, but ask the question, is that the right role for government, or should government build in restraints on its own surveillance so that it's only looking at transactions where there's some concern about actual wrongdoing? Obviously, we have concerns around anti-money laundering and those types of things, and we have to respect those concerns in this space, but at the same time respect people's interest in having their financial transactions private.
Thank you very much for your clear answer, Commissioner. Another question: principle-based regulations seems to lead to variety of interpretations. And sometimes the entrepreneurs or the inventors might think, well, if my interpretation does not match the regulator's interpretation, how should we do? What should be the way to resolve this kind of variety of interpretations upon the same subject?
Well, that's a great question. And I think, we talk about principles-based regulation, and then often what happens when you have principles-based regulation is people come in and they want more prescriptive rules to tell them what they can and can't do. So that's a very difficult balance to draw. It is important, I think, again, to communicate with people. You can provide guidance around what the regulator is seeing, for example, in a space that's causing it concern, and that can be helpful to people as they try to figure out how to comply with principles-based rules. But again, it's difficult. It's something we struggle with all the time, not only in the digital asset space, but more generally. But I think the key is to remember not to put into the rules things that really aren't core to achieving the objectives of what you're trying to achieve. You want to protect investors, but you don't really care whether someone does that using old technology or new technology. And so even conveying that message to people that really what the ultimate concern is the end objective of protecting investors and allowing innovation. And so if you can figure out a better way to protect investors, encourage people to come in and talk to you about that so that you can make sure that the rules aren't prohibiting that from happening.
Well, thank you very much for that. Another question, I think that the time still allows another 3.5 minutes here. How will the SEC address DeFi that offers regulated activity?
Well, I think that we're facing DeFi and looking at it, and it is challenging. I would say I hope that the way we approach it is to provide some help to people involved in this space as they think about developing projects. What should they be thinking about from a regulatory perspective? I hope that we do not take an approach that is regulate by enforcement. That said, I do encourage people in the DeFi space to be thinking about how the existing rules apply and to be working with regulators to think about what sensible rules would be. But really, we need to develop a regulatory framework that respects the unique benefits and unique challenges of DeFi, and that's going to need to involve people who are developing in this space, because there's so much. As a regulator, I know it's so hard to keep up with all the developments in the space, so it will certainly be a challenge.
Thank you. I think it's time for final questions. And this is the questions on the Bitcoin future ETF. What is the rationale behind approving Bitcoin future ETFs, but not the Bitcoin ETFs themselves? Is this the case that futures are already a regulated product, and approving futures ETF is therefore within the ambit of SEC, CFTC's regulatory authorities? But I mean, in short, I mean, in terms of approval of the Bitcoin futures ETFs.
Well, the questioner put his or her finger on, I think, a key aspect there, which is Chair Gensler has really pointed to the fact that the futures markets are regulated by the CFTC. The SEC, over my objection, I will say in the past, has pointed to the lack of a federal regulatory structure over the spot markets for Bitcoin as a reason to reject a Bitcoin spot-based exchange-traded product. I don't know that is. I've argued that's not consistent with how we've handled things in the past. I think for folks who want exposure to the crypto asset class, a spot product could be a much more effective and direct way to get that. But that's an ongoing conversation in the United States, so we'll see where it goes. But at least under Chair Gensler's lead, we were able to get an exchange-traded product across the finish line, and it's now trading in the United States.
Thank you. And last questions here. It seems that now the traditional financial institutions seem to invest in cryptocurrencies as well. Does that worry you at all, and what do you think?
Well, it does worry me in the sense that there is a lot of hunt for products that are yield generators, and there's a lot of yield being generated in crypto. So I worry both about retail folks participating and about institutional folks participating. But on the balance, I think it's important for us to get the insights of institutional actors and their thoughts. They are very compliance driven, and so they will be thinking about compliance issues, and that can be helpful then to us as we think about how to address issues like custody, for example. So getting people who have knowledge of the traditional markets involved in these markets can, at the end of the day, be quite helpful for us as we think about a regulatory approach.
Well, thank you very much for that. I wish we had much longer time asking you questions and ask you to give us a lot of thinking this evening, but unfortunately the time is up. However, I still wish to ask you to give some final remarks for all the participants this evening.
Well, I just want to thank everyone for tuning in so late in the evening. It's been wonderful to have the chance to speak with you, and I do have an open door, so meaning I'm willing to talk to people, at least virtually for now, but would love to talk to people who have thoughts in this space. I think it's digital assets are based on the premise of community involvement, and I think that's important as we regulate in this space as well. So I'm looking forward to having some great conversations with people in the coming months and years around these topics. Thank you so much for your time.
Thank you very much. I mean, your time and your comments and your thinking is deeply appreciated. Thank you very much, Commissioner Hester Peirce. Thank you very much.
Thank you, Whit.
ขอบพระคุณมาก สวัสดีครับ Well, I think that was the very valuable 45 minutes that we were hearing from the Commissioner Peirce, and I'm pretty sure that many of the thinking, many of what we have listened today will be extremely useful for all the regulators, including those who are here with us, even though they are not regulators. But I'm sure that this is extremely useful for that. Well, and that is the first day of the first SEC Thailand International Digital Asset Webinar, Policy Implications and Digital Asset Regulation, a peek at global movements. But this is only the first day. Tomorrow, we still have got a very, very interesting program ahead of us. Let me give you the program tomorrow. Tomorrow, we start at 1:30 p.m. here in Thailand, which is at around 6:30 Greenwich Mean Time or GMT, and that will be the topic, Policy Choices for Regulating Digital Asset Industry by Professor Douglas Arner, Curry Holdings Professor in Law, the University of Hong Kong. And a bit later on, approximately 50 minutes later, which is 14:20 or 7:20 Greenwich Mean Time, there will be a panel discussions on opportunities, challenges and barriers of digital asset businesses. And there are 5 panelists from different regions ranging from the UK, Switzerland, EU, Singapore and Korea, sharing their views and what's happening in their markets, as well as to share what should be the optimal balance between the innovation and the protection of investors at the same time. And therefore, there are still 2 equally interesting programs tomorrow. Don't miss it. And on behalf of the host for this evening, the SEC, or Security and Exchange Commission of Thailand, I'm Wit Sitivakin. I would like to thank all of you for joining us here this evening, or this afternoon, or this morning, depends on your region. Thank you very much and see you tomorrow once again. Thank you very much and have a very nice evening, nice afternoon and nice morning. Thank you.